and thank you for those of you who were able to take time out of your busy diaries to be here. So we hope today could be we can make the session as interactive as possible, and it is a fairly relevant topic for all of us, which is Mental Capacity Act and best interests. And I'm sure many of you are faced with the decisions on a daily basis. I think somebody is not on mute. My name is Sanjay Nilsson. I'm the Clinical Director for Learning Disability Services, and I have Ruth joining me today.
Good afternoon, everybody. I'm Ruth Cooper. I'm Operations Strategic Lead for Learning Disability in Elfton and Learning Disability Nurse by background.
So what are we hoping to cover today? And I'm not able to move my slides. I don't know why.
It's in the bottom left hand. Yeah, there we go.
Got it. Okay, thanks. So we'll start with true or false, and we look at the Mental Capacity Act and what it all means. And we'll look at some themes from LIDA in regards to Mental Capacity Act. And we'll also look at deprivation of liberty safeguards, the case law, and LPS, as well as case scenarios. So Jess, if you can put it in the chat, whether you think this statement is true or false. A person lacking capacity needs to object to the level of supervision for dolls to be considered. Do you think that is true or false? You can put it in the chat.
Doctor, what is dolls?
Sorry, it's should I said it's deprivation of liberty safeguards. It's something that we put in place when someone needs to be restricted against their liberties, any impingement on somebody's liberties.
Okay, thank you.
Okay, so we've got one answer of false, another answer of false. Oh, 3 for false, 4. Lovely.
Right. So I think the answer is false. So a person does not need to actively object to their deprivation for them to be considered for dolls. And we will look at this when in the coming slides. So the next question is liberty of protection safeguards, which is LPS, will replace the dolls system from spring 2022. Has anybody else heard about LPS? Do we think it will replace dolls from 2022? That's not 2020. It was supposed to 2020, but it has moved. So do people think that's true or false?
We've got 1 true.
Okay, that's good. It is true, and it should have been replaced in 2020, but then we had the COVID, and it's been moved to 2022. Hopefully, April 2022, that will happen. The understanding and application of MCA was not one of the learnings from the LIDA annual report of 2017 and 2018. Do people think that's true or false?
Everybody's gone shy on the chat now.
Okay, which is I think it's an unfair question, I suppose. It was one of the major learnings of the LIDA annual report in 2017 and 18, and again we look at the LIDA themes later in this presentation. MCA applies to persons who are 16 and over. Do people think that's true or false? Any takers?
Quite a few trues.
Okay, that is true. It does apply to people who are 16, persons who are 16 and over. DOLS applies to persons who are 16 and over. What do people think about that? True or false?
Not so sure.
Okay, so that is again true. So, and we will come to that in the slides, following slides. Okay, on that note, what is MCA? And most of you here would know this. The Mental Capacity Act 2005 came into force in 2007. Its aim was to protect and restore power to people who may lack capacity to make certain decisions due to the way their mind is affected by illness, disability, drugs, or alcohol. So what needs to be borne in mind is, yes, its aim is to protect and restore power to people who lack capacity, but it also protects those of us who provide support to people who lack capacity. So, for instance, for doctors, we do prescribe medications to some of our patients who lack capacity to consent to those medications, or those carers who provide very close care to people who lack capacity in terms of taking care, providing personal care, or restricting them from going out because they may put themselves at risk. So it protects those staff as well who provide close care for patients who may lack capacity. As we discussed, it is a law which applies to everyone age 16 and over, regardless of their abilities. So what does MCA state? These are the general principles that we need to bear in mind. And most of them are kind of what one would expect. Everyone has the right to make his or her own decisions. Individuals must be supported to make those decisions for themselves. So all those reasonable adjustments that need to happen so that we can enable people to make those decisions when it is challenging. And obviously, the caveat around unwise decision, just because someone makes a decision that we might deem as unwise, does not mean that they lack capacity to make that decision. And where someone is judged not to have the capacity to make a decision, that decision can be taken for them, but it must always be in the best interest. Treatment and care provided to someone who lacks capacity should be least restrictive of their basic rights and freedom possible, but still provide the appropriate treatment and care. And whenever we are making the decisions, and again, I'm sure that all of you consider that in your practices, we try to make the decisions such that we take into consideration, if this person had capacity, would these be the choices they would make for themselves? Two stages of capacity, test of capacity. Does the person have an impairment of their mind or brain, whether as a result of illness or external factors such as alcohol or drug use? So it's not like we can do a capacity assessment on anyone, but they need to fulfill that criteria of impairment of their mind or brain. Does the impairment mean the person is unable to make a specific decision when they need to? So it is about specific decisions. It's not about a blanket capacity assessment for everything. Some people may be able to make a decision around their treatment, medical treatment, but not be able to make a decision around their welfare and care. So and obviously some decisions are more complex than others. So if a person has a saving of £1,000, they would be able to make a decision around their welfare and care. But if they had a huge estate, then those decisions become complex. So it depends on the specific decision. Capacity assessment. Understand the information relevant to the decision. Retain the information. Use or weigh up that information as part of the process of making the decision. So this is the most important thing, and this is where we need to pay most attention, that ability to balance the pros and cons of making a particular decision. Often people are able to recollect the information given. They are able to understand the information at a very basic level, but understanding also means balancing the pros and cons of making a certain decision, and ability to communicate that decision. So in people with learning disability or elderly people, sometimes you have to make those reasonable adjustments so that they are able to communicate those decisions either through picture format or other forms of nonverbal communication, so that they are still able to communicate that decision despite may or may not having verbal communication at hand to do that. It is decision and time specific. As we discussed, it is decision specific and is time specific as well. So there is possibility that someone might gain capacity. So we see that all the time in patients presenting with delirium. But if they need immediate treatment, that decision need to be made now, and then considered whether and decisions need to be reviewed once they regain capacity.
Thanks, Sanjay. So just to pick up on some of the points that Sanjay's made, we must always presume that somebody has capacity. That's our starting point. And obviously over the last 18 months, we've had some very, very complex health situations to deal with in all elements of our care and at all levels of the health and social care system. So just wanted to think about some of the LIDAR findings. That's the Learning Disability Mortality Review findings that came out from the most recent report. And I'm sure most of you are aware that there was significant discussion about the use of DNA CPR, particularly for elderly, vulnerable people, people with a learning disability, and anybody that potentially was considered frail. We had a number of scenarios where people had a DNA CPR placed on their records without the relevant discussion. So decisions were made without the person themselves and their family carers, and also made on the basis of diagnosis. So, for example, we came across some scenarios where people had had a DNA CPR on the basis that the person had Down syndrome, which is certainly not the only reason why you would consider a DNA CPR. I think it's really important to consider everybody's feelings, and they are very complex decisions, we know that, but it's truly the place where MCA comes into its own in terms of thinking about the complexity of situations, what the person may or may not want, and how we best involve them in that element and decision making around their care.
So it might be useful to look at a case scenario now. We'll give a minute or so to look at this case scenario, and then we will switch over to Menti. For those who haven't used it, if you just type menti.com, and then it'll take you into a presentation which Ruth will display, and then you log in the number. But we'll say how to do that again when Ruth shares a slide. So this is a true case scenario. It happened to one of my patients in Hackney. DA is a 32-year-old gentleman who has moderate to severe learning disability and autism. He lives in a 24-hour supported accommodation and needs support with most of his daily living activities, such as food being prepared for him, clothes being chosen for him, always being accompanied by someone when he goes out, so on and so forth. He is able to feed himself, however. DA communicates predominantly in single words, and that is to mainly communicate his needs. He's on an antipsychotic to manage his challenging behaviors and is regularly reviewed by a psychiatrist. He suddenly stopped eating after one episode of vomiting blood and lost significant weight, requiring admission to the acute hospital. So this one episode of vomiting was as he was eating food. He was eating food as normally he likes chicken. So he was having chicken and rice, and he vomited, and then following that he stopped eating. He lost around 10 kilograms of weight in a period of around 2 to 3 weeks, because he completely stopped eating. In the hospital, he started drinking some fluids but was still refusing solid food. He had a physical examination and blood tests, all of which were within normal limits. The psychiatrist reviewed him on the wards and was informed that he would be discharged tomorrow as they haven't identified any organic causes and his presentation is likely to be behavioral in nature. So when actually I saw him, and my concerns were how will we cope in the community considering that he's still not eating and he's drinking very little and he has continued to lose weight on the ward. But the ward wanted him to be discharged. So if we think about that case scenario and look at the questions on Menti, Ruth will explain how we do that best.
Okay, if you could just stop sharing your screen for a minute, Sanjay, and I'll bring the Menti up. Thank you.
Okay, I need to find out how to do that now.
There's a bit at the top that says stop sharing.
Yes, all right.
So the instructions are at the top of the slide. If people can use their phones or their browser on their computer to go to menti.com, as Sanjay suggested, it gives you a code. It will ask you for a code to a copy to the presentation. And then the screen will come up with the question. And what we'd like you to do is type in and give us some answers about what should happen next in this scenario. So the code is there. It's 33 19 76 5. And if people could pop some answers in the presentation, we can see them come up on the screen and generate some discussion around them. Hopefully everybody should be able to log in. Sanjay, I don't know whether there's some additional comments come up on the chat. Is everybody able to log in? Oh, don't think so. The patient would just deteriorate in the community. Yeah, possibly.
Ruth, there's just a message on the proceed. I can't seem to be able to log in. Someone is saying.
Okay. So if you're not able to log into the Menti, please do use the chat as well, because Sanjay will be having a look at it. Thanks, Viola. Anybody else got any thoughts? Sanjay, is there anything coming through on the chat? Oh, no, definitely shouldn't be discharged.
No, there is nothing on the chat, Ruth.
Okay. So got a couple of answers that think no, probably not a good idea to discharge this gentleman. Do you want me to go through to the next question, Sanjay?
Yes.
Oh, hang on, we've just got another one come through. No, would be an unsafe discharge. Yeah, okay, lovely. So we'd ask yes, what we should consider. Actually, there was a fairly overwhelming answer saying no, we shouldn't discharge.
We should just go to the next slide.
Yeah.
Yeah.
So what should we consider if we're not going to discharge this young man?
What are the things to consider?
Anybody got any thoughts?
Anything at all? Right. Okay. Ruth, if you stop sharing, then I can.
Oh, no, we've got some coming through.
Oh, we got some. Okay.
So, needs further
Great.
investigations for loss of weight. Yeah, absolutely. Likelihood of deterioration in the community. Absolutely. And
Excellent.
reasons for his loss of appetite.
Super stuff.
Okay.
Right.
So,
So
you want me to stop sharing?
yes, yeah, all that seems the right thing to do. So I guess with this particular patient, we had reached a point when the hospital wanted him to get discharged, and my main discussion with them was around the fact that the patient himself lacked capacity, and we need to make a decision whether to discharge him or not in his best interest. So the hospital were lovely. There's no problem with the hospital at all. It's just this particular case just helped me understand that it's just about asking those questions. And as soon as you ask, our colleagues are so obliging in terms of thinking on those terms. So we did have a best interest meeting for him, and it was decided that it wasn't safe to discharge him, and he needed further investigations. And he was put under general anesthesia, and they looked at him through an orthodontist checked him out, and what they found was a small bone of chicken lodged in his gums, which was removed, and following which he made a miraculous recovery, and he started eating almost from the second or third day. So that is a true story of what happened with someone like him, and it was a really good outcome for him. He's back in the community and he's doing well, but it's sometimes just about thinking around the needs of the patient and the framework. So the best interest checklist is again pretty much what all of us will be thinking when we see patients in our clinics. Will the person be able to make the decision in future? What are the wishes of the person? What are their beliefs and values? What other factors should be considered? What do other people who know the person well think would be in the best interest? What would be the least restrictive option? So much of what we had already discussed before is what we need to be looking at. And I'm trying to move the slide again. Yep.
So the second scenario, and remember those principles of MCA when we look at this. So JB is a 45-year-old gentleman with moderate to severe learning disability. He's been on high-dose antipsychotics to manage his psychosis, which is well managed, and he's not currently open to secondary mental health services. He's overweight, and in the last couple of weeks, he's been steadily losing weight despite a good appetite, and this is accompanied with increased frequency of micturition. JB has not had any medical investigations in several years because he won't engage with them. Carers have made an appointment with you as his GP to see what your thoughts are. So we're going to, I think, Sanjay, do you want to use the chat for this rather than the Menti?
Yeah,
or
that's fine. Yeah.
So if people can put their thoughts in the chat about what your first questions should be or thoughts around this gentleman, that'd be great. Okay, got possible diabetes, further blood tests, urine tests. Absolutely.
So people are right in thinking that those are the things from a medical standpoint, but what you have to pay attention to is that he has not engaged in any medical investigations in the past. So what are your options in such a scenario?
So one of the things, okay, would you be willing to have a fingerprint test at the very least? Okay, so how might you find out that? How might you consider what options are available to you? And what JB might be able to engage in? Yeah, ask him.
Good.
Yeah, definitely.
make best interest decision.
So, yeah, absolutely discuss with next of kin and involve family members. When we make best interest decisions, what needs to come first? So do we need to establish whether he has capacity to consent or understand when he's not engaging with these health? Yes, lovely. Least restrictive, yes, absolutely. So ideally first we want to elicit and understand what he understands about what's happening to him as part of a wider capacity assessment, and that means asking him, as people have quite rightly pointed out, his family, his carers, and understanding what's meaningful for him. Then if he doesn't have capacity, yes, absolutely, it would start to consider a best interest decision making and what might be the least restrictive, which that's a really important point. What's the best option for this person to achieve the outcome? Any other thoughts from anybody? Do you want to move on, Sanjay?
Yeah, so obviously the other things to kind of consider is if you're having challenges and having investigated, to engage the local learning disability team, which I'm sure you do, for their nursing staff to get involved, to support the patient, to work around things like needle phobia if the patient is experiencing needle phobia, and then, I mean, as a last step, consider whether he needs some sedation to have it done and the level of sedation. But the most important thing is to do all of that in a framework that protects both the patient and yourself as the clinician.
So some of these scenarios featured very significantly in all reports since 2016 for the Learning Disability Mortality Review. And I don't think it's just people with learning disability. It's, as we mentioned, people who are perhaps affected by drugs, alcohol, people who are frail, people with dementia. So similar themes, but certainly coming out of the LIDAR review, documentation around mental capacity assessments and best interest decision making is sometimes missing or poorly recorded. Now, quite often, I'm sure we do have those conversations, but from a legal standpoint, it is absolutely crucial to record those and record exactly what decision you need to make, exactly who's been involved, how information was shared with the person and their carers, and then thinking back to when Sanjay mentioned those 4 points. So how did the person receive the information, thinking very considerably about whether they were able to weigh it up and then communicate their decision. And still we are seeing people that are perhaps not as involved in those discussions as we would like them to be. And even if a person, or you feel that a person doesn't have capacity, you can still share information with them to try and elicit their wishes, even if they can't balance and weigh up the pros and cons of the choices. So it's really good to be able to have them as part of the discussion, because we need to think about what's best for them ultimately, don't we? And you know, nobody wants to use high levels of restriction to gain an outcome. We want to do it in the least restrictive way. So delay or absence of the use of MCA and best interest decision, again, was something that featured quite highly, both in terms of acute illness, but also thinking about how people were treated in terms of their care and welfare. Were decisions made in a timely way? Quite often this features in people who receive a late diagnosis of cancer, where perhaps the appropriate tests haven't been carried out in the normal streamlined pathways that perhaps you and I might take. And that's really challenging, because we still see lots and lots of people with learning disability dying from late diagnosed cancers, when actually they have as much right and opportunity to be involved in screening as the rest of us. Key theme was the lack of understanding of roles and responsibilities and competence in discharging the duties placed on professionals under the Act. Now, and sometimes that still happens. I know that, you know, a lot of us feel concerned about the decision making. It's quite a complex process for those bigger decisions. But actually, if you're the one leading the care for an individual, then actually ultimately it's your responsibility to take the lead on rolling out this process. And sometimes that can feel quite uncomfortable when it's very complex or controversial, but we still have to do it. And groping the experts, I mean, Sanjay and I would be the first to admit that we seek advice on a regular basis from our colleagues in our legal departments and our experts on Mental Capacity Act, where there are really difficult decisions to be made.
Ruth, there's a question around what is LIDAR themes?
LIDAR themes. So the Learning Disability Mortality Review, just to put it in a bit of context, is a national review process. It's just about to change, which I'll talk about in a minute. But the Learning Disability Mortality Review started in 2015-16 and came from a confidential inquiry which involved 256 cases and reviews of people with a learning disability and those in the general public. And the outcome was, from that confidential inquiry, that people with a learning disability were 3 times more likely to die from a preventable death or from care that was not commensurate with what we would expect from the rest of the population. And showed clear inequities in the health care delivery system for people with a learning disability. Now that programme has been rolling, Learning from Lives and Deaths, yeah, lovely. So that's the new policy, and that came out earlier this year and is a staged process. So the new policy continues to review deaths, and what happens is that a death of a person with a learning disability is reported to central LIDAR system, and then reviews are allocated to independent professionals who will now sit within ICS footprints, who will undertake either an initial or a extended review of a person's death to really understand what was the good practice and what was the poor practice. Possibly helpful to be aware that not only people with learning disabilities, but from the end of this year, it will also include autistic people, which will bring some challenge, because I think autistic people quite often experience the same health inequalities, but struggle to often get diagnosis, so we're not clear of diagnosis, quite often don't feel confident to engage in services. So again, looking at inequity and how we consider how we make reasonable adjustments to improve the delivery of healthcare for that group of people. Does that help? Sanjay, have I covered everything that LIDAR stands for?
I think you have. So I guess in summary, it is just learning from deaths of people who have a learning disability, learning from the deaths of people who have a learning disability. And as we know, that there's been so many times in our generations where people with learning disability have died due to various reasons, and LIDAR is a way of keeping tab on that. So I think the most important point for me as a clinician here is about that delay or absence in the use of mental capacity assessment and best interest decision making. So if we reflect on the case study that we just had, you guys were on the ball, you know, thinking of PSA, thinking of diabetes, etc., etc. But the challenge is, if we do not have investigated, will you go into diabetic ketoacidosis or worse? Those kind of questions. And there's where the use of Mental Capacity Act in a timely manner matters. And now, when you think about people not being vaccinated because they lack capacity and other challenges, that's in other place where we need to be thinking of timely use of Mental Capacity Act and best interest decision making. So we have fortunately not been losing patients with learning disability in the last few months. But one of the patients that we lost in the trust was a man who was unfortunately not vaccinated. So vaccination remains, as you all know, vaccination remains the most protective thing for everyone, and especially so for people with learning disability, because they've been at more risk of death during the pandemic.
So just as Sanjay's probably summarised very well already, some of the outcomes of those challenges with MCA are delays in diagnosing and treating serious medical conditions. Quite often it happens in end-of-life care planning, and whilst there is some excellent end-of-life care planning in some of the areas that we work in, there's also some really sad and distressing stories where people perhaps haven't either died in the place they wanted to or how they wanted to. So it certainly leads us still to challenges. Pain management is another issue for us, and quite often there still remains this idea that people with a learning disability have very high pain thresholds. Quite often that's not actually the case, but we need to understand how we measure pain in this population, and for that matter people with dementia or other frail people, because quite often communication is quite difficult when somebody's in significant amounts of pain. So understanding how we do offer pain management is really important to many of the pathways that we manage. And as Sanjay said, urgent proactive treatment is not being delivered in line with clinical guidelines and pathways, including blood tests and various other interventions, which really can lead either to very late diagnosis or delayed intervention, which could change the outcome for a person. So last case scenario, so FT is a 60-year-old lady with Down syndrome and Alzheimer's dementia. She lives in a supported accommodation with sleep-in staff support at night. And in the last couple of weeks has been wandering away from her home at night and has been returned back to her accommodation on several occasions. What do we think can be done to minimise the risks of wandering?
If you start putting it in the chat as before, that'll be super helpful. So if that's the kind of scenario that you're presented with in your surgery, what things would you be thinking about? Someone who's put something. Doll's assessment, excellent.
Yeah,
Adam on the ball.
okay.
He's cut to the chase.
Yeah, bedside
Wicked,
alarm,
getting
secured
accommodation
gate.
tonight. Good. Review by memory consultant, excellent. Bedside alarm, wow, that's a good one as well. Bed and door alarm.
Quite a few good ideas, and absolutely Dole's assessment. Well done, that person. So Sanjay, do you want to?
Yeah. So deprivation of liberty safeguards, it aims to prevent the unlawful detention of adults in hospitals and care settings who lack capacity to choose where they live and or to consent to care and treatment. So if we reflect on the case presentation that the case scenario that we just had, so this is a lady with dementia, Down syndrome and dementia. So her condition is likely to be progressing, and it is progressing. So she would need certain level of restrictions to manage the risk of her wandering away. Now, we deliberately use the word wandering in learning disability and not use the word absconding. Absconding kind of signifies that that's being done out of choice, but wandering suggests a state of confusion, which leads to the person going away from the place of safety to not so much safe places. So with her, the things we would absolutely consider all of those things that you said to be seen by a memory consultant. Consider the least restrictive thing, which would be to have a bedside alarm and a door alarm. And yet there is a problem here. If she tries to leave, the staff will have to stop her, which means we will be depriving her of her liberty. Therefore, for her own safety as well as that of the staff who support her, who would be in this precarious situation of stopping her, we need to have a legal framework. And that legal framework, if she were to live in a residential home, will be dolls. If she lives in a support accommodation or one's own place, then we'll have to go to court of protection to get the dolls. Now, dolls authorization can either come from the local authority when you lack capacity, and that can be done. That can be sought in a straightforward way when you live in a residential home. But when you live in a support accommodation or shared lives and so on, you'll have to approach the court of protection and get authorization from the court of protection, which sometimes can be a longer process than going through the local authority. There are two key questions to ask described as the acid test. Is the person free to live? Is the person subject to continuous supervision and control? So those are the most important questions to be asked. So when we think about, one of the true or false questions that we ask, if the person is not trying to actively leave, can we just not put them on any kind of legal framework? And the answer is no. If the person is not free to leave, that is, if they try to go out of the door, the staff will stop them, then they are being deprived of their liberty. If the person is going to be on continuous supervision and control, so in some ways, when you think about the bed alarm and the door alarm as well, they are some form of supervision and control, despite them being not a kind of a human thing, but a technological control over the person's movements. So if those two questions are answered, then we need to, are in the positive, then we need to consider a legal framework to manage patients.
Thank you. So we know that the Mental Capacity Act has been in place. The recent legislation or changes in legislation, so there's an Amendment Act in 2019, and that actually set the process rolling to replace the current DOL scheme with a new scheme called the Liberty Protection Safeguards. And that was due to come into force in 2020, as we spoke about right at the beginning of the presentation, but has been delayed due to numerous issues, and not least because of the pandemic and the challenges that the last 18 months has been brought. So it's now due to become legal practice in April 2022. The next slide, please, Sanjay. So the Liberty Protection Safeguards are a little different. So they will provide protection for people aged 16 and above who need to be deprived of their liberty in order to enable their care or treatment. And it specifically applies to those that lack mental capacity to consent to the current arrangements where they're having care. So responsible bodies will be hospital managers for arrangements in an NHS setting or hospital, the CCG or local health board, or in cases where a person is eligible for continuing healthcare. And the local authority will be the responsible body for all other cases, so those living in a social care approved setting. Next slide, please. And this becomes a three-stage test, so slightly different again. So there will be a capacity assessment, that doesn't change. There's then what they're referring to as a medical assessment, and that's really to understand the nature of whether somebody has an impairment or a mental disorder, which is impacting on their capacity. And then what's going to be referred to as a necessary and proportionate assessment. And this will determine if the arrangements are necessary to prevent harm to the person and proportionate to the likelihood and serious nature of that harm. So again, just thinking back to case scenario 3 and the lady that Sanjay described leaving the house, we'd need to think very carefully about what the key risks were to that person, how we might in the least restrictive way prevent that, and then consider whether that's proportionate or not. These would all be done by independent assessors. Thanks. So the conditions to be satisfied before arrangements could be authorised were that the person lacks capacity to consent to the arrangements that are proposed, that they have a mental disorder, and that the arrangements that are proposed as part of their care plan are necessary to prevent them from harm, but also proportionate in relation to the likelihood and serious nature of that harm. And proportionate is, I guess, the flex in the system, if you like, because we need to think very, very carefully about what that looks like. And that's probably key where the independent advocates that people require as part of this process and family are likely to be involved, because actually what is one person's proportionate quite often isn't another's. So that's where the independent eyes come into this part of the process. So there's some specific changes in addition to the ones we've mentioned. There's a greater emphasis in involving family and all of those people involved in a person's network in the decision making. So there's now a very explicit duty in the Act to involve those involved in the care and welfare of that person. And whilst it's always been best practice to do that, quite often it hasn't happened in the way that we would like it to, which is why it's now an explicit duty. So just to be clear as well, that 16 to 17-year-olds will now come under this legislation rather than some previous applications to the Court of Protection. So the Liberty Protection Safeguards will apply across from 16 upwards, which is quite key because quite often some of the challenges we have around that grey area in transitioning into adulthood between 16 and 18. And probably the biggest change in lots of ways is that the Liberty Protection Safeguards will also be applied in domestic settings. So as Sanjay described earlier, previously, this was only limited, DOLS was only limited to formal settings, such as residential care, hospital or supported living. So this can now also be applied in the person's own home.
And I think that's a big change, because that combined together, that 16 to 17-year-olds will be under the legislation and it can be applied to domestic settings is the big thing, because in our care, we see most of the 16 to 17 years old living with their parents and at home. And when they come and they become adults, suddenly there is this whole issue around the restrictions. So I guess this will be a better way of practice in many ways, that we consider those restrictions when they are still children, and it just doesn't feel like a cliff edge when they turn adults, when we are considering all this kind of what looks like a punitive measure for some level of legal framework to be placed on someone. So that's a major change.
So we've got a bit of time for questions. I guess in conclusion, mental capacity is something that we all need to be aware of, to use and implement in our everyday practice. As Sanjay said, if you're in any doubt around somebody who has a learning disability or even somebody who's under the care of a mental health CMHT, then actually you can always contact them for support and guidance around how to do that and how best to involve everybody in that person's network and care. There is a good web-based tool and the link is there, and the presentation will be shared afterwards so you have access to that. But also I think there's something about considering how we as services strengthen governance in relation to how we use MCA and think about training and audit of compliance on a very regular basis so that we fully appreciate the role that we have under the legal requirements of the Act. Because it is challenging, it's not straightforward. The requirement of MCA to be decision and time specific quite often brings some challenges in particularly urgent or complex situations. So as we said before, there is advice and guidance out there, and the primary reason to do this is actually, as Sanjay said right at the beginning, to protect the person, but protect yourselves professionally as well, to ensure that you've worked through every stage to come to the best outcome. So is there any questions from anybody? If you want to pop them in the chat or take yourselves off mute, and we'll do our best to answer them.
I think when you're waiting, I just want to add that, you know, mental capacity is everyone's business, is what what we are kind of trying to say. But also, as doctors, we are not expected to do a mental capacity act on every decision. So it is those decisions that impact on the treatment that we are providing as treatment. So if you are providing a certain treatment, or you think somebody needs to have a certain treatment or management, that is the capacity that you need to be able to assess and manage. So there is a question.
Yeah, so if LPS will be applied in people's homes, is it the family who enforce it? Is there a risk of this being abused? That's a really good question. It's a really good question.
So
Go on, you go, Sanjay.
no, I was just about to say that yes, agreed with that, and I suppose the issue is that without safeguards, people get abused anyways, and I guess that's where it comes from. So there are many places where the doors are locked, and the person who lives there does not have the key, so they're not at liberty to leave anyways. So it is those kind of situations where the safeguard will protect them. What it also means is if somebody is on LPS, they have regular reviews from either the local authority or whichever the governing body which places them on it. So they perhaps have better protection than what they would have otherwise. And the families who enforce them as well have some degree of protection, because otherwise they're just doing it because they care about the person they love. And the third point is that, of course, it depends on the issue for which the safeguard, the restriction is sought. So that is what will define whether they are at increased risk of abuse. So if somebody's doors are locked because they're at risk of getting into an accident, that seems a fair enough thing to do. But if somebody's food has to be restricted because they have a certain they're either obese or eating too much, then that becomes more of a human rights question. And it is used in the community to restrict people's liberties around eating food already, but then just kind of looking at both sides of that argument, as Adam was pointing out. Ruth, is there anything else that you would want to add?
No, I don't think so. I think you just illustrated really well the challenge in the different decision that you're making, and I think we also need to acknowledge that safeguarding adults goes very closely alongside this. So not only do we have a duty around MCA and LPS, but we also need to understand that if we come across a scenario where perhaps this isn't legally applied, then we need to be mindful that there potentially is a safeguarding scenario here, and that we need to be in a position to advise families and carers and the person themselves about the legal considerations and decision making that needs to be part of it. So they go very, very closely hand in hand.
Are there any other questions? Sorry. Just asking whether there are any other questions. That was a really good question from Adam. Right, I don't think there are any other questions coming in, Ruth. But so I would like to thank you all for being here and making it a really interactive session. I think for us, we should have been more mindful of some of the terms that we are using, the LIDAR and dolls and so on. But we'll take it away, and the next time we will expand those presentations. Any advice about giving medication a patient refuses? That's a good question. I'm going to kind of give a general spiel around it, because it really depends on the situation. So one is assessing the person for capacity. If they lack, well, if they do have capacity, then it's all about that kind of providing that education around medications and working with the family and networks and the staff who know them better to help them take the medications. If they have communication issues, kind of trying to use easy read versions and pictures and so on, And some of this can be helped by your local speech and language therapist to kind of prepare that material to help them understand. If they lack capacity, I would still do all of those things that I've just suggested, but then think about things like covert administration of medications if necessary, and follow your local covert medication administration policy as well. And the most important thing in all of these things is accurate documentation, contemporaneous, accurate documentation, record keeping, and to think, well, is this a reasonable thing to do? And if your colleagues would do that, then if you think that all of my colleagues would do a similar thing, then I think you should do that. So those are the general suggestions I can give without actually knowing the ins and outs of a case. Does that help? Yes,
Lovely.
okay, thank you. So I think it's 2 o'clock, and I'm sure all of you have to rush into another meeting in the world of virtual life. But thank you again for joining us this afternoon.
Thank you, everybody.